Here to discuss the unusual trial so far in the Karen Read case, trial attorney and legal analyst Misty Marris. Misty, great to see you. The jury deliberated for over 20 hours. They had over 60 witnesses. They had 600 pieces of evidence to go through. But how unusual is that?
So this was a huge trial, and a lot of it was because much of it, the defense was raising what's called a third-party culprit defense, and the prosecutors knew that. And so in order for prosecutors to set forth their case, they had so many witnesses, so much forensic evidence that they were presenting to the jury. So this is a highly, highly complicated and complex case, and a lot of that comes from that defense that prosecutors were very aware they were going to have to overcome in order to prove their case beyond a reasonable doubt.
Going back to the judge, also said to the jury they didn't give enough time and consideration to the case after they said they were unable to reach that unanimous verdict that Caitlin just talked about. What would prompt the judge to say that to the jury?
So this was actually a very, very significant legal issue. So as Caitlin said, the jury came back and said they were deadlocked. The judge had to do an analysis at that point. There was the prosecutor and defense both presented an argument. Prosecutor said enough time has not passed. Defense asked for what's called a dynamite charge to be read. Now, that's something that you have in every single state. In New York, it's called the Allen charge. In Massachusetts, it's called the Toohey-Rodriguez charge. That is a specific jury charge that says the jurors go back into the jury room and listen to the minority of those who are not in consensus, listen to each other and try and come to a consensus. Now, it's legally very relevant because once that charge is read, if the jury comes back a second time and says they're deadlocked, the judge has to let them go. That is a deadlock. That is a hung jury. So what we can expect moving forward, They've said they're deadlocked. The judge refused to read the charge, said it was premature. So Monday, before the jury can actually be hung, that Toohey-Rodriguez charge has to be read. And then they have to come back again and say they haven't reached a consensus. So there's a little bit of legal gamesmanship going on here about when that charge will actually be read to the jury.
I know this next question is a bit complicated to answer, but do we have any indication on what the outcome could be with everything we've seen so far?
So there's a lot of people who have differing opinions on this, but for me, I thought the investigator Proctor, who was the lead investigator in the case, his text messages were so damaging to the prosecution's case. I would be surprised if there was not a hung jury. I don't think we're going to see a conviction. Maybe not an acquittal, but a hung jury, I think, is very, very likely. And especially now that we know that the jurors were unable to come to a consensus, came to the judge and said, we've really tried, but we could not get there. There's one element in all three crimes that she's charged with. Keep in mind, there's an intentional murder charge, there's a manslaughter charge, and then there's a lesser charge of leaving the scene of an accident causing the death of an individual. What do all three of those charges have in common? They're different levels of intent, but they all require the jury to find beyond a reasonable doubt that Karen Read caused the death of O'Keefe. So if jurors are not in concert on whether or not she actually hit him, remember, we got the third-party culprit theory, that's something that could absolutely hang the jury on all three of these charges.
If Read is convicted, what is she facing?
So it depends on which charge she's actually convicted of. There's the intentional murder charge. That's the highest. That's life in prison. Then the manslaughter charge. That's up to 20 years. Then leaving the scene of an accident. This is all because she was intoxicated at the time and resulting in injury or death. That could be up to 10. So it's truly dependent on which level of crime she is ultimately found guilty of.
Thank you for that, Misty. There's another case I want to talk to you about, something you and I have discussed before. A judge officially denying a request to have Alec Baldwin's involuntary manslaughter case thrown out. What does the denial mean for Baldwin? What can we expect to see when this case now begins? It will begin in July.
He keeps trying and trying, which is absolutely what his defense attorney should do. And quite frankly, this was his strongest argument because this last motion was different than the rest. The other motions said there's not sufficient evidence. They're kind of your typical motions that any defense attorney is going to make pre-trial. This one specifically relates to the gun. The gun at issue was destroyed during FBI testing. And so his defense team used that as a basis to get the case thrown out. They said this case, it's all about the gun. We didn't have the chance to actually do any independent analysis. Therefore, it's highly prejudicial. Case should be thrown out. Well, the judge said no. So now this case is going to go to trial, and we're expecting 70 plus witnesses to testify. We're going to see a lot of what we saw in Hannah Gutierrez Reed, but there are some witnesses that we know will be different. For instance, there's an individual who prosecutors have said actually observed Alec Baldwin pulling the trigger of the gun. And so that person is going to be testifying. That's a central issue to the case. The legal theory is a bit different, but a lot of the evidence is going to overlap from what we saw before. But there's still an argument from the defense team about whether or not those reports relating to the gun can be precluded, whether or not certain testimony regarding the gun is precluded. So all of those evidentiary issues are different than what we saw in the motions to dismiss.
Misty, you are incredible on how you keep everything so simplified, case to case to case. Like, there were a lot of questions at you. You impress me every single time. Misty Marris, thank you so much.
Well, thank you so much. Have a great day.
Please come back soon.